name is Heather, and this is an update in the Idaho 4 case. And I know I've been kind of behind on these. I've kind of slipped in my paying attention to this one only because it's kind of been just boring motions, and I really didn't feel like they were necessary to bring to you guys. But this week, or this past week and a half or so, we've had some interesting motions coming through. So, in regards to the change of motion or change of venue motion that the defense has brought forth, they need to prove in some form or fashion that the jury pool in that area is going to be very prejudiced by media and whatever. So they have to prove that, and in order to do so, they need to gather information, obviously, from prospective jurors. However, the state wants to bar the defense from talking to any potential jurors, and they've done that um, in this motion here, which is a motion to temporarily seal the state's motion for order prohibiting contact. So basically, the state wants to prohibit contact with prospective jurors unless the court says so, unless the court is aware of it. And they, and like gives permission or whatever. I don't know. So I don't know if that's necessary, but I mean, I guess so if it's a court order that they're not supposed to. So before we dive in, please like this video, please comment, subscribe, do all those YouTube things as my channel continues to grow. I am really, really thankful for all of my views and likes and anybody who subscribes. I really appreciate you guys. And even if you're just a watcher, thank you. All right, so comes now the state of Idaho by and through the Latah County prosecuting attorney, so Bill Thompson, and hereby moves the court pursuant to Idaho Court Administrative Rules, blah, 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 for a temporary order sealing the state's motion for order prohibiting contact with prospective jurors absent leave of court, herein because this is the reason why he wants to prohibit any contact with these potential jurors, the jury pool. One, it would interfere with enforcement proceedings, which I don't know how, but okay. Two, it would deprive a person of a right to a fair trial or an impartial adjudication. Number two, again, constitute an unwarranted invasion of personal privacy. Number three, but really four, disclose the identity of a confidential source. And or five, disclose investigative techniques and procedures. So those are the reasons why they are seeking an order to seal their motion, basically prohibiting contact with prospective jurors, and those are the reasons why why it should be sealed. And then here's an order prohibiting contact. So this is from Judge John Judge. So order prohibiting contact with prospective jurors until further order of court. So on March 22nd, 2024, the state filed a sealed motion for order prohibiting further contact with prospective jurors absent leave of court. The same day, defendant Brian Koberger filed an objection to the state's motion with the promise of a forthcoming affidavit and memorandum in support of the objection. Having reviewed the materials submitted, the court enters the following order. One, both parties are prohibited from contacting potential jurors about this case, including via third parties, until further order of this court. And number two, a hearing on this issue will be held as soon as practicable, I think is how you say that word. All right, so that was issued on the 22nd of March. The next motion we're going through a bunch of motions because these are all interesting, and we're going chronologically, so just so you know. All right, so this next order, it's an order sealing objection to the state's motion. So basically, the court agreed to seal the state's motion that was moving to order prohibiting contact with prospective jurors. Okay. So he agreed to seal it. Now, this is a temporary order sealing the state's motion for order prohibiting contact based upon the state's motion to temporarily seal the motion for order. So they must have temporarily sealed it before they sealed it finally, right? Or no? Having before it the defendant's motion to seal. So he sealed the defendant's motion and the state's motion. So that's what that is. Okay, so now this is another filing from Ann Taylor to the court. It's a memorandum in support of objection to the state's motion for order prohibiting contact with prospective jurors absent leave of court. So here is why. Here's why they object to the state's motion. So comes now Brian C. Koberger by and through his attorney of record and C. Taylor, public defender, and hereby submits this memorandum in support of objection to the state's motion for order prohibiting contact with prospective jurors absent leave of the court. Telephonic surveys to explore the media stories the juror population has been exposed to is not a violation of this court's revised order issued June 23, 2023. The state has alleged that the defense has violated this court's revised order. Specifically, the state alleges that the defense has violated the prohibition on discussing the identity or nature of evidence expected to be presented at trial or any sentencing phase of the proceedings. The order also prohibits the disclosure of any information a lawyer knows or reasonably should know it's likely to be inadmissible evidence in trial, and that would, if disclosed, create a substantial risk of prejudicing an impartial trial. So the defense is aware of these prohibitions. After all, the defense wrote the order, the original order upon which it is based. So it's like, oh, we're aware of the prohibitions because we wrote it. We wrote the original motion. All right, so the state, however, misunderstands the prohibition in this respect. The defense is not disclosing information. The defense is asking prospective jurors in the county of Latah as to what information they are aware of that was previously disclosed vis-a-vis the press. So all they want to know is, what are you aware of? What things have you heard? They're not trying to disclose or disseminate any information. They're just trying to gather information, is what they're saying. So further, the revised order for non-dissemination allows for counsel to ask questions of the public to do its work. That is exactly what happened. Mr. Koberger, in his preparation for his change of venue hearing, is mindful of what the court must consider and the available means to obtain information for his evidentiary hearing. Idaho Criminal Rule 21 and relevant case law guide the factors a court must consider in a motion to change venue. The state's motion and the court's order intrudes on one of the ways the defense will seek to establish prejudice pursuant to ICR 21, State versus Haddon. So the Idaho Court of Appeals outlines relevant factors a court must consider when taking up a change of venue motion prior to attempting to seat a jury. Extensive publicity, accuracy of publicity, and the size of the community from which the jury would be drawn. The Haddon Court, in referencing the size of the county as being small, said, however, the fact alone does not require the presumption of prejudice, nor would such a rule be practicable given the relatively rural nature of many of Idaho's counties. The Haddon Court also said a party challenging venue must bring, quote, more than the size of the community. Certainly, pervasive media coverage that continues to this day is a factor and will be discussed in a later hearing. The focus here is on critical survey work obtaining information to support the change of venue motion by establishing, quote, the more, in addition to the size of the county, the important work will establish the reasonable probability of prejudice. So they want it for information gathering purposes, and they need it. They not just they want it, they need it because they need to bring forth to the court more than just, well, the county's small, so obviously it must be prejudiced. It can't, you can't, you need, as with everything in law, you need to bring receipts. You need to back it up with proof. So to provide the defense hired Dr. Brian Edelman, owner of Trial Innovations, and we're going to read an affidavit from him shortly, and it's going to be interesting. So Dr. Edelman is an experienced doctor of social psychology with additional educational achievement and experience in statistical surveys. It likely will help to understand how surveys are done in cases such as this. The survey, to be valid, must be done by a random selection of contacts. The number of surveys are small, but enough to see trends that are attributed to a larger population. The questions in the survey seek limited but important information to qualify the surveyors first to qualify. Should be a comma there. To qualify, the surveyor first asks if the person reached is an adult Latah County resident. Then the survey continues with opinion, exposure, and connection to the case questions. Dr. Edelman, after extensive research of the media coverage in this case and with approval of counsel, designed the media influence questions around statements that have been made in the media. As counsel for the state wrote in their motion, many of the media influence questions are not factually correct. That is exactly the point. This is what the Haddon court said in relation to extensive media coverage. Non-factual media dissemination is more harmful. So, like, how many people are still talking about the fact that Brian Kohberger said, did they arrest anybody else? When in actuality, that was just something on a news report, and it was never substantiated and backed up by any evidence. And people are still talking about it. And it's going on with many other pieces throughout this case and other cases where the media gets a hold of information first, and the first line of information where they're getting it is usually law enforcement or the prosecutor's office, the district attorney's office. And if they're putting out misinformation, it's on the part of usually them. Just saying. But anyways, law enforcement or the DA. So that is what the Haddon court said in relation to the extensive media coverage. Non-factual media dissemination is more harmful. It would be of little use to this court to know that there was a deluge of unobjectable media coverage. The only way for this court to have a way of understanding what the parties would face with a juror from Latah County is to know what they are being exposed to. As Dr. Edelman can testify, that is the sort of work parties do in these cases. So there is, you can get people to survey and find out what the jurors know, and this is exactly what Dr. Edelman does with his research and survey statistics and all that. So it may be new to some in Latah, but it is still the industry standard, professional, and ethical way to do this. There is no realistic possibility that this will affect the jury selection in Latah County. The problems with the county are not of the defense's making. They are what the defense wishes to expose for this court. Very well said. Conclusion. I like that. So the state's motion is filed against the backdrop of Mr. Kohberger preparing for his motion to change venue. The state objected to the court scheduling a change of venue hearing, and now, through this motion, is thwarting the defense preparation for the motion. The state knows counsel for Kohberger did not violate the revised non-dissemination order. The state and counsel met the day before the state filed its motion and discussed the content of the survey and received the curriculum vitae for the expert hired by the defense. The state was informed that these types of surveys are not an anomaly. However, the state filed its motion anyway. The state's motion should be denied, and the order prohibiting future contact with prospective jurors should be withdrawn. So this comes after the court already sealed everything up and approved everything, and denied all, or not denied, well, basically, ruled against the defense and gave um, gave the prosecution all the wins. So this is coming on the 26th, so 4 days later, saying this should be withdrawn. It was not done right, and there's big issues here. So we're going to read the declaration of Brian Edelman, PhD, who solemnly swears and declares and affirms he is a co-founder of Trial Innovations, Inc., a national full-service jury research firm. I have worked as a trial consultant for 20 years and have conducted pretrial and post-trial research on both criminal and civil cases across the country. I have been retrained as an expert in over 70 high-profile cases to assess the impact of pretrial publicity on the fairness of the trial proceedings. And then he lists some of his cases, which I don't know all of them, but one includes Colorado versus James Holmes. I believe he was the movie theater shooter. And then the state of Florida versus Nicholas Cruz, who was a school shooter. All right, so counsel for the defendant in State of Idaho versus Brian Kohberger retained me to research and evaluate, 1, whether there was extensive and prejudicial pretrial publicity surrounding the unaliving of 4 students attending the University of Idaho in Moscow. The community panic then ensued, and the search for a suspect, which ended with Brian Kohberger's arrest. Number 2, determine if the media coverage has impacted the defendant's ability to obtain a fair and impartial jury in Latah County. Number 3, whether community residents in alternate venues exhibited similar bias. And 4, based on the findings, recommend appropriate remedial measures, for example, a change of venue to protect Mr. Kohberger's ability to be tried by a fair and impartial jury. As part of my analysis, I evaluated relevant newsprint, television, and social media coverage surrounding these events and conducted a community attitude survey of 400 residents in Latah. Comparison surveys in alternative venues have yet to be completed. These surveys were designed to assess case recognition, familiarity with prejudicial media content, and bias. All right, so here are his qualifications: education and experience. A copy of my curriculum vitae could be found in Appendix A to this declaration. Upon completion of my undergraduate education, I received an MA, so a master's, and a PhD in social psychology from the University of Nevada, Reno, and from the University of Kent in the United Kingdom. My graduate studies have provided me with a broad foundation in both qualitative and quantitative research methodologies, as well as statistics. The social psychology program at the University of Nevada is unique in that it is one of the few in the country that has an emphasis on the application of social psychology theory to the legal arena. That's very interesting. During my studies, I specialized in jury-related issues and examined how attitudes, race, stereotypes, pretrial publicity, and other factors influence juror and jury decision-making. In this regard, I took coursework addressing topics associated with change of venue motions, the impact of pretrial publicity on jurors' ability to be fair and impartial, and the steps necessary to conduct a change of venue analysis. The university's association with the National Judicial College and other governmental agencies also afforded me the opportunity to conduct research with the public defender, district attorney, court services, the judiciary, and other institutions in Washoe County, Nevada. Sorry, Nevada, I don't know how to say that. All right, so research experience. I say that so far I think he's very qualified to do this research and make some and provide quality expert feedback based on what he said so far. So, research experience. While at the University of Nevada, Reno, I worked as a research assistant and project manager at the Grant Sawyer Center for Justice Studies, where I assisted with several national surveys, including one that examined the judiciary understanding and application of the Daubert standard. I also, that's the name of a case, you know how one case sets the standard. So that's the Daubert. I can't remember what Daubert means. Now that's going to really bother me. I think, does it have something to do with, let me see. I know what it means. Okay, Daubert allows a court to act as a gatekeeper of expert testimony and play a more active role in shaping the admissibility of trial testimony. The gatekeeping function is intended to ensure that any and all scientific testimony and evidence admitted is relevant and reliable. So Daubert has to do with the court allowing expert testimony, expert witnesses' testimony based on her, I guess, whatever. I don't know, her experience as a judge. Him or hers, sorry. And this is judge. I'm working on so many cases right now and it's female judges, so I keep saying she, but I mean he in this case. All right, so he did the Daubert standard. I also explored how jurors minimize what they have read, seen, or heard about high-profile cases during voir dire. In addition, I oversaw a study of the Washoe County's pretrial release program and assisted with the development of training programs for foreign justices, court administrators, prosecutors, and defense attorneys who were brought to the United States by the Department of State. Further, I have conducted and published research on the impact of illegitimate factors on juror decision making. The research included developing and testing a model that attempted to explain how factors such as race and empathy influence pre- and post-deliberation sentencing decisions in capital cases. My research on juror decision making in capital cases was later published as a book. So since completing my studies, I have also published on the impact of graphic images on jurors and on methodological issues associated with online survey research. Jury research experience. I began working as a trial consultant in 1998 and I co-founded Trial Innovations in 2010. Over the years, I have worked on hundreds of criminal and civil cases across the country. As a trial consultant, I have conducted mock trials, focus groups, surveys, post-trial interviews, and other research exercises. I'd say that's pretty qualified. I have consulted in the courtroom and assisted with jury selection on more than 100 cases. I have also served as a presenter at local bar associations, law firms, national meetings, and conferences. In addition, I have been invited to conduct MCLE courses related to jury selection by the public defender, alternate defender, and district attorney in California, Nevada, and New Mexico. I have also served as a guest lecturer at the University of Santa Cruz, St. Mary's College, and Stanford Law School. Wowzers, this guy's busy. Venue experience. As a graduate student, I was trained by Dr. Ronald Dillahay and Dr. Edward Bronson, two of the leading experts in the country on venue and pretrial publicity. Over the years, I have had the opportunity to work with Bronson on a number of change of venue studies. I have worked on change of venue issues in several different capacities as a researcher. I have coded trial transcripts in high-profile cases to evaluate how jurors minimize their bias and exposure to pretrial publicity during voir dire and the challenges this phenomenon poses for juries and attorneys. Basically stating, no, I'm not prejudiced at all. I love people of whatever race. But then you get there and the person of that race is there and it's not my race and I really do have these prejudices that I'm holding and now I'm going to vote this person guilty in my verdict. You know what I'm saying? So I think that's what they're trying to avoid. In addition, I have examined the impact of television pretrial publicity on prejudgment of guilt. I have also presented as a panelist on change of venue issues at the American Society of Trial Consultants annual conference and been a co-author on the chapter in the California Criminal Law Procedure and Practice on change of venue since 2011. Man, this guy's busy. I have conducted content analyses of media coverage on a host of topics and have designed more than 50 community attitude surveys over the years. I have been retained as an expert to conduct and evaluate change of venue studies and also to recommend remedial measures for addressing exposure to pretrial publicity outside of a change of venue. Expert witness experience. I have been retained as an expert witness on matters including freedom of religion in China, political asylum hearing, eyewitness identification, and change of venue. I have testified as an expert witness in person or by declaration in California, Idaho, Colorado, Texas, Michigan, Florida, Massachusetts, Nevada, Pennsylvania, Tennessee, West Virginia, and Washington in state and federal court. In the majority of cases, I have been retained to conduct a change of venue study. I have recommended against the change of venue. Okay, so they say this excludes instances where I have been hired to review a change of venue survey, assist with addressing media coverage during voir dire, or review trial transcripts and pretrial publicity. Okay. The influence of attitudes on cognition. And this says cognition is a term referring to the mental processes involved in gaining knowledge and comprehension, including thinking, knowing, remembering, judging, and problem solving. So all of the things you would need to be a juror. There is a substantial body of literature documenting the impact of attitudes on information processing. Attitudes have been shown to have an impact on selective attention, the evaluation of new information, memory recall, and behavior. This research provides insight into how media coverage may lead to juror bias. This would be outstanding if they published like papers and books on this and really showed us, we need to put some parameters on our media to not be just blatantly putting out false information, and they need to vet their sources and whatnot. Once upon a time they did have to do that, but now not so much. Pretrial publicity can have a prejudicial effect on jurors through its impact on the information of attitudes and beliefs that they bring into the courtroom. Attitudes are not isolated entities, but are often linked to other memories, experiences, attitudes, and beliefs. These links can create large networks of attitudes which are resistant to change. So it could be like built in your neural pathways, these prejudices and biases that you don't even know you have because of the way you grew up, because of things that you overheard as a child. Those are all going to impact the way you look at the world. And people all have bias. They all think with bias, whether you want to or not, because we all have different experiences and we've all, been through things. So we have experience and knowledge in other things. So, we feel knowledgeable in certain aspects and whatnot. So your bias is always there, but you don't know. Anyways, so attitudes are not isolated. These links can create large networks. So like I said, like neural pathways. The links between attitudes strengthen with repeated activation. So you strengthen your attitudes the more and more you reiterate them. So if you are a staunch Republican and you have to always watch the news, you're going to watch the Republican news. You're not going to necessarily watch the news with, Democratic sources or with Democratic angles, because it's probably likely going to make you mad. Although most news coverage for politics makes you mad anyways. But And it's designed to. It's supposed to be inflammatory. And those are things that I think we need to look at as a society and say, we shouldn't want this. We should want facts and real evidence being presented to us and not, you know, worrying about did Karen Reed have an affair with Brian Higgins? Oh my goodness, when actually they're trying to divert attention from the Karen Reed case and that she's an innocent woman being framed by the government. So, yeah. Anyways. The links between attitudes strengthen with repeated activation. As these links strengthen, the probability increases that the attitudes and underlying beliefs will be consistent with one another and brought to awareness simultaneously. Again, I'm going to use that news coverage explanation or analogy. If you continually watch things about politics that's going to make you angry, then you're going to be drawn to that, and it's going to affect your attitudes in life. It's going to affect how you see the world. You know, if you watch angry, yelling newscasters all day about politics, it affects you. It gets into your psyche whether you want it to or not. And that's what this is talking about. It's there within you, within your DNA, within your neural pathways, and some of these fears and biases you can't always control. So that's why these questionnaires are so important, or these surveys. So attitudes that are strongly linked to one another are more easily accessible in memory and more likely to be automatically activated with exposure to the attitude object. So attitudes can be activated automatically without any conscious intentional processing. This is more likely to occur when an attitude has been repeatedly activated in the past. We got a footnote. That's just the source it's coming from. Okay, so when media coverage surrounding a case is broad, extensive, and redundant, strong links between relevant attitudes and beliefs begin to form. If the pretrial publicity creates links between case details, attitudes, and beliefs over the course of a trial, these attitudes are likely to be automatically activated at a subconscious level. So literally just looking at a picture of Brian Kohberger, if you are an avid guilter and you think Brian Kohberger is guilty, literally just looking at a picture of him on a subconscious level can activate that. Oh, I'm so biased. I don't like him. I don't like that guy because I have already associated him with the crimes because the media has already told me he did it. And that's the problem. That's what happens a lot of times to people. So, as described below, this network of linked attitudes can be an impact on a juror's attention to and evaluation of the evidence and arguments presented in court. This is fascinating to me. I think this is awesome. All right, so just like knowing how the human brain works, it's so cool. So as the network of linked attitudes grows and strengthens, specific attitudes become resistant to change because change requires revisions to other attitudes and beliefs within the network. So changing one thing leads to a domino effect of having to change a lot of things, and people don't like change. So changing one thing is hard enough. Imagine changing all these other beliefs and attitudes. Resistance to revising well-established attitudes has been shown to lead to biased information processing. When attitudes are strong, there is a tendency to favor arguments and information in support of those attitudes over arguments that may disprove them. So, confirmation bias. I'm a Republican and I only listen to Republican news, and anything outside of that is wrong, in my opinion, because that's my attitude. I'm not saying me. I'm just saying, like, for example, that's how I've shaped my mind. So one thing leads to another, all these different pathways. The acceptance of a counter argument can create cognitive dissonance. For example, people list more counter arguments for information that refutes pre-existing attitudes and information that supports them. Oh, I read the wrong one. Sorry. It says cognitive dissonance is an uncomfortable feeling caused by holding two contradictory ideas simultaneously. So if I believe that all Democrats are bad, but I have a friend who's a Democrat, oh, what do I do? My brain can't handle it. That's cognitive dissonance. And that's, again, this is just an example. Don't come at me with political whatever, because this isn't what this channel is about. So take that somewhere else, please. Um, so further, wait, the links between, did I read that? As a result, the latter is more difficult to retrieve from memory. Wait, attitudes can have an impact on attention and recall. Okay, sorry. In an effort to avoid cognitive dissonance, information that supports attitudes may be selectively attended to, and counter arguments may be distorted or dismissed. There's where this comes in. For example, people list more counter arguments for information that refutes pre existing attitudes than information that supports them. So I might have more counter arguments in my brain than actual information that supports them, but I have to selectively change my attitudes to support whatever I believe. Attitudes can have an impact on attention and recall. Research has shown that information that supports a pre existing attitude is easier to learn, more accurately retained, and easier to recall. The links formed between attitudinally supporting information and pre existing attitudes are stronger than those formed between counter arguments and pre existing attitudes. So that's pretty self explanatory. As a result, the latter is more difficult to retrieve from memory. Further, there is a tendency to produce new beliefs which support pre existing attitudes and suppress those that run counter to such attitudes. Your brain will make it make sense somehow, even if it has to create new memories. In sum, when a venue is exposed to prejudicial media coverage surrounding a crime, there is a risk that potential jurors will develop a large network of linked attitudes and beliefs relating to the victim, the defendant, and the crime. These linked attitudes include opinions about the guilt of the defendant, appropriate sentence, and evaluations of the evidence presented through the media. When the links between attitudes are strong, they can be activated at a subconscious level and have an impact on the juror's valuation of the evidence and arguments presented at trial. So, like I said, you could just look at the defendant, look at his face, and go, oh, that guy is so guilty. Because you've already, in your mind, created the neural pathways to believe his guilt. Even though those neural pathways might have been created by lies that were told from the media. Attitudinally supporting arguments will be more closely attended to, evaluated as persuasive, integrated into the existing network of attitudes and beliefs, and made easily accessible during deliberations. In contrast, counter arguments and evidence conflicting with well-established attitudes may create cognitive dissonance. As a result, jurors will either ignore the evidence or make cognitive efforts to refute it. This evidence will not establish strong links to pre-existing attitudes and will not be easily accessible during deliberations. When a venue has been saturated with pretrial publicity, these psychological processes can put the defendant at a significant advantage, undermine the presumption of innocence, and diminish the prosecution's burden of proof. The prejudicial impact of pre-existing attitudes is accentuated by the fact that the media coverage underlying them is often biased in favor of the prosecution. Very true. Furthermore, news content is coded under very different circumstances from those found in the courtroom because the rules of evidence that are strictly enforced at trial do not apply. That's a big, big key thing. Things that should have been thrown out because it's old or doesn't count or whatever. There's, you can't bring in past bad acts or whatever it may be, but if you allow that to filter through in the news, well, oops, it's already out there and it's already persuaded my jury. All right, so did I finish that last sentence? As such, the persuasive impact of information presented through the news media becomes more significant and ingrained in the juror's mind than the evidence presented at trial. That's key. So people who have been exposed to the media might believe things that they heard from the media still, and they might even discount things that they've been presented at trial because it doesn't match with the beliefs that they've already shaped. the prejudicial impact of pretrial publicity. There is a body of research within the social sciences that attempts to address the impact of pretrial publicity on decision making in the courtroom. This literature suggests that pretrial publicity influences evaluations of the defendant, perceptions of criminality, sympathy towards the defendant, pretrial judgment regarding guilt, and final verdicts. And that's all coming from that big source right there. Daftery, Kapoor, Penrod, O'Connor, and Wallace conducted a field study that incorporated real-time evidence into the methodology. Okay, those are just citations. Participants included jury-eligible community members who were naturally exposed to pretrial publicity over a 14-month period leading up to the trial. Trial summaries were presented online during 6 sessions over the course of 10 weeks. The researchers reported a pretrial publicity effect that persisted throughout the actual trial. Despite the admonitions to set aside prejudicial pretrial publicity, participants were biased by the content of the pretrial publicity. So if we know this is happening, why are we allowing this to happen? Why do we allow our media to do these things? Who is stopping them? Nobody. Specifically, those exposed to prosecution-oriented articles were more punitive in their guilty ratings across all 6 sessions compared to those exposed to pro-defense pretrial publicity. The amount of pretrial publicity participants were exposed to also had a significant amount or effect. So the more publicity they heard, the more effect it had on them. In addition, the biasing effect of pretrial publicity did not disappear over time. Thus, neither delay nor trial evidence eliminated the pretrial publicity effect on judgments of guilt. Steble et al. Conducted a meta-analysis encompassing 44 research studies on pretrial publicity. The authors reported a statistically significant relationship between pretrial publicity and verdicts. Media coverage addressing the defendant's prior record, the existence of confessions, the heinousness of the crime, the negative character of the defendant have all been shown to have an effect on pretrial perceptions of guilt and final verdicts. Furthermore, deliberations may not produce the biasing impact of pretrial publicity. In fact, Kramer, Kerr, and Carroll found that deliberations actually accentuated the effects of pretrial publicity on final verdicts. So deliberations is a chance for them to all start talking, and they start all reaffirming each other's pretrial publicity beliefs. Dexter, Cutler, and Morgan, oh, that's funny, Dexter Morgan, also reported a significant relationship between pretrial publicity and views towards guilt. Participants were given pretrial publicity a week before the study began. Negative pretrial publicity increased conviction rates, even for subjects who underwent extensive voir dire addressing publicity pretrial. As demonstrated by Ruva and McAvoy, exposure to pretrial publicity can influence verdicts by affecting perceptions of defendant credibility, ratings of the prosecuting and defense attorneys, and source attribution errors, misattributing information learned from the media as evidence presented at trial evidence. My dog's gonna go out, and I still have much to read. So, if you can bear with me one sec. I have to go. Where did I leave off now? Alright, I gotta take him out. So, hold on one second. Where is it? We'll be right back. sorry about that. I had to take the dog out. He's had stomach issues lately and off and on. All right, you guys don't need to know that. Where were we? So, consistent with the experimental literature on attitudes described above, Hope, Mimon, and McGeorge found that jurors exposed to negative pretrial publicity evaluate pro-prosecution evidence more favorably than its actual probative value, a phenomenon coined pre-decisional distortion. So a lot of people think the prosecution and law enforcement are all perfect, it's all going to work out, they did their job and there's no reason to question the police investigation and all that. But that is not the case. We all have rights, and all of our rights need to be adhered to and upheld. Even if you are convicted of a crime, you still should have rights. And that's what this is all about, is making sure that we're getting everybody a fair trial. All right, so thus, attitudes developed from exposure to pretrial publicity serve as a filter through which later trial evidence is evaluated. Telephone survey. A telephone survey of 400 residents was conducted in Latah County. The sample size of 400 was calculated via a power analysis to reach an industry standard 95% confidence interval of plus or minus 5%, using the most conservative response distribution, 50%. Comparison surveys were planned into 2 alternate counties to assess if any potential bias found in Latah County carried over to the rest of the state. The survey instrument used in this case adheres to industry standards established by the American Association of Public Opinion Research and the Change of Venue Survey Professional Code established in the American Society of Trial Consultants. The survey instrument topics of focus and questions were constructed after reading more than 269 articles that referenced the unalivings of the Moscow Pullman Daily News, the Idaho Argonaut, and the Spokesman Review. Steps were taken regarding the structure and flow of the instrument and design of the questions to mitigate potential threats to internal validity, including response bias and order effects. All of the questions in the survey instrument, including the media recognition items criticized by the government, were carefully selected based on how pervasive each item was in the coverage. None of the media recognition items included any information that was not widely reported and available in the public domain. The rest of the survey instrument focused on respondents' opinions of the defendant, prejudgment, and experiences during the search for a suspect. The survey measured residents' exposure to media coverage, the extent of the case knowledge, and their opinions regarding the case. The survey was conducted by Research Strategies, Inc., a consumer public opinion and business-to-business market research firm, for 36 years. So, I mean, he is totally validating this research that the government is trying to just go, whatever, we don't need. Their data has been used in 49 districts, federal district courts, and the U.S. Department of Justice. They programmed the screener and the survey into Research Strategies, Inc.'s proprietary computer program, Research Express. Patricia Reinhardt, vice president, led, trained, and instructed for this telephone polling project. Research Strategies, Inc.'s Research Express program was thoroughly tested prior to the implementation of the survey. Research Strategies, Inc.'s in-house telephone operations center is manned with experienced, professionally trained researchers familiar with conducting change of venue studies. So these aren't just any old people you found off the street that you're paying $5 an hour to call. I mean, these are people that know what they're doing. Research These researchers are specifically selected for their demeanor and speaking ability and have a combined average of 9.6 years with Research Strategies, Inc. With a mean average of 52.5 years, Research Strategies, Inc. restricts the minimum age for these researchers to 25 years of age. So they have strict policies for hiring the people that are conducting the research. Respondents who refused to participate in this survey were not called again. Research Strategies, Inc.'s protocol is continuous on-site monitoring of each telephone researcher that validates a minimum of 5% of each researcher's calls. They follow standard procedures developed by the Marketing Research Association as well as data collection guidelines for the Council of American Survey. To successfully win a change of venue motion, the defendant needs to demonstrate that the media coverage has generated bias in the community that undermines his or her constitutional right to a fair and impartial trial. The standard method for measuring prejudgment and fixed opinions within a venue is a community attitude survey. There is no other accepted scientific method for doing so. So let me read that again. The standard method for measuring prejudgment and fixed opinions within a venue is a community attitude survey. Let's highlight that. I like to highlight stuff as I read. All right, so that's good. There's no other accepted scientific method for doing so. By preventing the defendant from completing this survey, the government is impeding his ability to collect the data required to meet his burden. I'm going to highlight that too. It's a great sentence. Will the government then criticize the change of venue motion for failing to demonstrate widespread bias and fixed opinions in Latah County? Yes, of course. Yes, of course, the government will criticize that, and you're blocking them from being able to actually get the data. So the survey design methodology I used in this case comports with surveys I have presented in numerous other cases, which other courts have found to be valid and objective when considering to need to change venue. For example, in California versus Quinton Ray Beeler, the court granted a change of venue largely based on findings from my telephone survey, which were cited throughout the decision, stating that Dr. Edelman appeared to use a measured, objective analysis of the bias for a change of venue. The Beeler court also found me to be an experienced expert in the area of change of venue. In United States versus Sablin, the court concluded that the potential for influence creating bias is apparent as reflected in Dr. Edelman's survey. Indeed, Dr. Edelman's survey shows actual bias in more than half the potential jury pool. So there was bias in more than half of the pool. So the notion that polling 400 community residents, 1% of the Latah County population 18 and over, is the cause of potential bias in a county that has been saturated with hundreds of highly prejudicial newspaper articles, television news stories, and social media posts is not credible. Unlike the media, individual residents do not serve as a communication channel for disseminating information across the county. There is no evidence that conducting the survey has had any impact on the master list of prospective jurors or potential venue in this case. I think that's supposed to say venue. Or voir dire. I don't know. One or the other. The survey in Latah County has already been completed. It is my opinion, unless the government is willing to concede the point and waive the issue, that it is necessary to complete comparison surveys in alternate venues. This is the only method for demonstrating that there are counties in Idaho that are significantly less biased against the defendant than Latah County. I declare under penalty of perjury. That's facts and true. Okay, Brian Edelman. So that was his affidavit or memorandum, in support of the objection to the state's motion for order prohibiting. So they don't want to be prohibited from contacting the jurors, and that's why they've put this forward. This is Brian Edelman's resume. I'm not going to go over it, but I'm just going to briefly show it. You can see he's done a lot of research on courtroom analysis. in the social psychological area. And then, oh wow, those are all his cases. Interesting. Anyways, so those are some cases he's done. Let's move on to notice of hearing. Notice is hereby given that Brian C. Koberger, by and through his attorney Ann C. Taylor, public defender, will call on for hearing the defendant's fourth motion to compel in the above entitled matter. I don't know why it says fourth, because it's their 15th motion to compel, but or as soon thereafter as counsel may be heard in front of the honorable judge. That's from Ann Taylor. And finally, this is the defendant's 15th supplemental request for discovery. So I don't know what that other one was to compel, but this is to compel discovery, 15th. Number 15. They have asked now 15 times for all of the discovery in this case from the state of Idaho, who refuses to hand it over. So please take notice that the undersigned, pursuant to Rule 16 of the Idaho Criminal Rules, the 4th, 5th, 6th, 8th, and 14th Amendments to the Constitution of the United States and all those articles of the Constitution of the State of Idaho, request discovery and inspection of all materials discoverable by defendant and the aforementioned constitutional provisions, including but not limited to the information, evidence, and materials outlined in the IGG. Defense counsel will hand deliver a copy of Exhibit N to Bill Thompson. Okay, so they're saying they still just have not received the discovery, and that is unfortunate because it just keeps delaying and delaying. But we already know we're pushed back till like next summer, so following summer, not this summer, but next summer for trial. Anyways, that is it for the Idaho for these are mostly last week's or the last week and a half's motions, which I thought were interesting, so I wanted to bring them to you. So thank you so much for watching. Let me know in the comments below what you think, and I hope to see you in the next one. Take care. If you've been impacted by a true crime and would like your story told in your own words, or if you or someone you know has been wrongfully convicted or accused of a crime, please write to crimeincourtchannel@gmail.com and tell us your real true crime encounters. Thanks for watching.